Good afternoon, ladies and gentlemen. I am Tom Munns, for those who don't know me, and I am with my esteemed colleague Ron Nielsen. He is the author of The History of Federal Lands in the United States and the Violence of Faction. I was talking to him a little bit off air, and I thought, maybe people just need to understand how this issue affects them. And so I think maybe that's something that we're going to have to work on. Anyway, um, as we usually do, I go through and give you a rundown of what our previous video was. That was book video number 12. For those of you that have the book, we went through page 43 to about 46, and we talked about incorporation. We talked about the 6-point doctrine for in Downs versus Bidwell. Sorry. Um, we talk about Idaho statehood, some interesting things that are not very well known. We continued to talk about the territory and and how the territorial, whether it's part of the U.S. or it's not, and some of these things. So it's very important for us to be able to do that, which is probably why we continue to hit it. We talked a little bit about something that is I've never heard before. It's called the 16th parcel, having to do with surveying and dividing into sellable lots. We talked a little more about Downs versus Bidwell. We talked about the diversity of citizenship. So that's later on in the video, if you can catch that. We talked about unincorporation, foreign territories, consular tribunals, which is something you're really, really going to need to want to hear about, and Idaho's admission into the Union. So, Ron, before I give it to you, man, just how's everything going for you?
Going pretty good. I realized after our last interview, I probably needed to apologize to everybody. I get a little twisted up on some of this stuff because, and I'll explain why, and maybe it'll help you understand why I get so I get a little angst in me. But I want to apologize for the bad language. I'll clean that up as we go. The thing that's causing it is this. There was two land inventories done by the federal government. There was a 53-54 land inventory and another one done in 63-64 timeframe. The 53-54 land inventory, these are big volumes, big books. They're hard to get, right? It used to be able that you could find them on the internet, but I think as this information is becoming more mainstream or getting more out there in the mainstream, these things are becoming very difficult to find. Um, so the land inventory, one of the last parts of the land inventory report out of the 53-54 one under the Eisenhower administration, the the executive branch Eisenhower told the team that they needed to send that report to all affected states. Now, there was no recommendation in there as to what the states should do with this information, but the states would have had this information at their disposal. Now, the way that I think is the state has a responsibility to its citizens to protect them. And if they get this report from Congress and this report goes against everything they thought they believed about the state and the federal land and talks about the use of the exclusive power in these areas, maybe the state might want to protect its citizens by letting them know that when they get out of a political subdivision, a state political subdivision, into one of these areas, that they're going to need to conduct themselves differently. If they would have done that, they could have prevented loss of life. They could have prevented a lot of economic destruction as these people have fought the federal government and this, that, and the other thing. There's a lot of things that we are experiencing now that could have been prevented
J6.
by the state.
I mean, even
And it
even
makes me
today.
so mad that I lose it a little bit. And I want to apologize for that because it's not, it's not what I want to be. But by the same token, I understand the level at which the state is culpable.
Mhm.
They're culpable, right?
Y-
They are not innocent. And even though we have different people running the state right now who can say, well, I wasn't a part of it. It's like, I'm sorry, but ignorance is no excuse. It's just no excuse. And I don't buy it. I wouldn't be given that excuse. If I had to go to court and I just said, well, I didn't understand the law that I was breaking, what would they tell me? Ignorance is no excuse. That law does not only apply one way, it's multi-directional. Okay. All right.
Well,
So that's the reason why I get so, and I apologize.
I think we also, it's pretty clear that we have a grasp on the ginormity of the situation. And I think a lot of the frustration that you and I both share, um, where we really have to bite the tongue sometimes, is
Oh, yeah,
dealing with people that just you possess this information and people are just so unwilling to review what it is. Now, granted, there's a lot coming at us and people are busy and people are trying to
yeah,
put food on the table. Granted, we know all that. And my
yeah,
argument is the enemy don't care. If you give
that's
them your
right.
country because you're too busy, at some point, the busy people, we know in our organization that the busiest people make the best leaders. Why is that?
Yeah,
They're the ones that don't have the time to do anything, and yet they're the ones that do the best job. We don't want anybody that we have to pry out of their couch. So
I
we
it,
understand.
I
We
think it's
understand.
Jordan Peterson. So here's what I would say to that, Tom. You're right, 100% right. I think Jordan Peterson talks about this a lot, and I love the way that he talks about it. Clinical psychologist, so he deals with this all the time. And he's like, okay, it's in how you use your time, right? It's in how you schedule and use your time. And there's a lot to that. It's not just a simple statement, and you recognize that that statement holds some truth to it, and you try to walk away, and that's the end of it. It's like, no, you don't understand. It's the same question for everybody that hears it, regardless of where they're at on the chain or in the hierarchy or whatever. It's the same question, and it has kind of a net equivalent result, meaning that depending on the subject matter, we are going to have some level of responsibility to the state, the government structure, our social communities, our children. We have some level of culpability and responsibility to each other. And when I'm telling you things that you need to know for your safety, for your children's safety, when you leave one of these areas and go into a federal area, and you say to me, well, I don't want to hear it, don't really care. You put yourself at risk, you put your children at risk, you put your wife at risk, you put your friends at risk
And your country.
because you don't know how to conduct yourself properly when you leave the political subdivision of the state.
Amen. True statement.
You see?
Yep.
So you can do whatever you want to. I'm not here to tell you what to do.
No, it's just that their
However, there's a
inaction is going
consequence
to
for everything.
their inaction is going to cause problems for us too. So we have to try to reach out to them the best way we know how.
Right,
So you
right.
you so I think uh sorry if I'm a one trick pony on this one, but I think we left off on 46. And one of the statements on
Yeah, I think
46 that
you're
came
right.
out was here's where we can isolate the political use of the terms membership into the Confederacy and membership into the Union. And I thought maybe I would just let you take off from there and go wherever you want to.
Yeah, so one of the things that I haven't done up until now is shown the receipts on that. I've been saying it, um, but I haven't really shown the receipts. So what I took the liberty of of taking some border states, and so here's what I mean by a border state. Let me bring up a map of the United States here real quick. Um, and let's see. Okay, we'll just use this one. It's nice, colorful. Oh, maybe not that one. Let's try that. Yeah. Oh, there we go. Okay, here we go. Now I'll screen share this.
There's no audio problems, by the way.
I
That
don't know
moment of
why it takes me
silence
so
might
long to
throw
do this.
people off. Okay,
Okay, sorry.
that's good.
Uh, hopefully you can see the map here.
I
I think I'm
can.
seeing it
I
on the
can.
screen
Yep.
share. Okay. So let's go. So right here, I've got my little magnifying glass here. Can you see it? Little
Yes.
cursor.
Mm-hmm.
This line right here, this is our 98th meridian. And this is the line of demarcation that the government likes to use for a lot of its legislation. And I'll give you an example of some of the legislation: the multiple use, both of the multiple use acts, the the uh, Clean Water Act. All right, so there's a whole bunch of organic acts that are operative from the 98th meridian this way
Mm-hmm.
at some level. Inside the act, you're going to find that demarcation.
Okay.
Okay, so let's go back to the book here. Okay, and on those border states, you have you got Iowa, you got Minnesota, Arkansas is further down, but it's kind of part of this. Of course, Louisiana, right? These are the border states right there on that 98th meridian.
Sure.
And when you look at their admission acts, those people, and you look at the admission acts from the 98th meridian eastward, right? The other direction. This is the kind of language that you're going to find, and I put it in the book as examples. Okay. Um, Declared to be states of the United States of America, be one of the United States of America, be one of the United States of America. That's Arkansas. Louisiana, one of the United States of America. You get to Missouri, which is one of the further states down further south, and they didn't do that. Well, it's actually in the middle. So you had the Missouri Compromise. So I was trying to figure out, well, wait a minute. Missouri is a border state, on the 98th meridian. It borders
Mm-hmm.
the 98th meridian. Why were all the other eastern states admitted into the Confederate agreement and Missouri was not? It was admitted into the Union. And I went, oh, that's right, the Missouri Compromise. You see, you could only be admitted into the Confederacy if you agreed to the terms of the Northwest Ordinance. And the Northwest Ordinance had a slavery proposal in it. And if you didn't agree to it, you couldn't be admitted into the Confederacy. So the compromise was that they admitted Missouri into the Union and not the Confederacy. And then when you look at all the admission acts west of the 98th meridian, all of them say admitted into or one of the Union, admitted into the Union. Very different language than. So again, you have to keep in mind. Let's go back to that map. We'll stop the screen share here. Go back to the map. It's
Good.
it's
I'll
it's
jump in real
helpful to
quick.
have the
Yeah, I want to
visual.
tell
Go
you
ahead.
that so this was on we're going through page 46. I don't know if you included the map. It seems like you did, but it's not on this page. But I wanted to tell you, just for your own sake and for the viewers, that having the map while you're looking at this and having you explain what it is makes it crystal clear. I just thought I'd
Okay.
put that in there.
All right. So you see, here's the Missouri, and it's right next. I mean, here's your 98th meridian right here.
Hmm.
Right? So it comes down this way. And Missouri's right on that line, right? But Iowa, Minnesota, Arkansas, and Louisiana, they were all admitted into the Confederacy,
Hmm.
right? The United States of America was a style of the Confederacy.
Hmm.
But you see that Missouri, the language in the Missouri Admission Act does not say that. Let's go look at it one more time. The Missouri Act. Shall be admitted into the Union.
Wow.
You see, these are very, very different. Admitted into the United States of America, one of the United States of America, one of the United States of America, one of the United States of America. Now we're going to admit Missouri into the Union. You see what I'm saying here?
Yes.
The language in these admission acts is very different in what they're being admitted into.
Yeah, I mean, look at
And when you,
just the explanations alone. It's twice as long as the other ones.
yeah, Yeah. So, and then I think Missouri was the only state east, or yeah, east of the 98th meridian that was admitted into the Union. Everything west of the 98th meridian was admitted into the Union. Everything.
So when it talks about the
Prior to
equal,
that,
okay, go ahead.
so this is the reason why we have the equal footing doctrine in the federal court system. This is the reason,
Oh,
because there was two different admission um, programs. You had the enabling legislation that created the one of the United States of America. That was actually enabling legislation, northern and southern.
hmm.
But the admission into the Union, there's no enabling legislation for it. None. So this is where this is part of the receipts for what I've been talking about that I'm just now showing you because we just got to that portion of the book. Um, that really rocked my consciousness, rocked me because here I'm seeing this definitive. So I'm seeing the United States of America and the admission acts in the eastern states that were underneath this program, and I can see the intent. Anybody could see the intent here. And it was this issue that made me look at the preamble to the United States Constitution because I'm like, I realized I don't think I understand the preamble very well. Because the preamble, let's look at the preamble of the United States Constitution one more time.
Oh my gosh. Here we go.
Go away. Okay, stop share. All right, we gotta do this differently. Okay, so preamble to U.S. Constitution. Share screen share. Be a little bit easier this time. All right, here it is. This is out of the National Archives. So I try to go to legitimate government websites to get as much of this stuff as I can get. All right. So we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for, on behalf of, the
Hmm.
United States of America, which is the style of the Confederacy. So I had to understand what this was saying. And in order to do that, I had to go back to the Northwest Ordinance. And when you read the Northwest Ordinance, you see that the entire intent of the land program was that all of the states would be part of the Confederate agreement. But when the Confederacy was abolished,
They all had to be
right?
part of the
So when
Union.
we talk about you and I off screen, we were talking about, you were saying, well, people don't understand the intent of the system, and maybe we need to discuss that. I'm like, you cannot discuss the intent of the constitutional system without starting here.
Hmm. It's
I
true.
couldn't. I couldn't make sense of it. But when I went, well, wait a minute. Okay, if the intent of the system was a Confederate model and the Confederate model was abolished, what model was there to take its place? Well, they invented it, they created it, and it turned out to be a vassal state arrangement. They were already doing it in the Western United States, they just implemented it across the nation at the close of the Civil War. And it's not that big a deal as long as the vassal state arrangement doesn't produce what we're experiencing now. And the reason why it produces what we're experiencing now is because of the exclusive power exercised domestically, which allows them to get around the restrictions that are in the Constitution, which means that they can form any type of federalism they want to
So should we
out of thin
assume
air.
should we assume for the listeners that that with the abolition, like I don't, lack of a better term, of the Confederacy, after the Civil War, that the natural default of the states was to be grafted into the Union?
Yes.
Okay.
I think, well, not the Union. I mean, are you talking about the intent or what it became?
I don't know.
Okay, so the intent
If we're looking at
was to be
Confederacy
grafted in.
versus Union, right? If you drop one of them, the Union's left.
Yeah, so if you get rid of the Confederacy, all that's left is, well, there was no other model. They had to
Okay.
create it,
Okay.
right?
Hmm.
But they didn't create it out of scratch. They
Hmm.
were already doing it,
Right.
right? So there was a portion of the Downs versus Bidwell case that I've read to everybody, in which the judge, one of the judges, I think it was Justice White, he was breaking down what he had learned from the Department of Justice attorneys in arguments at bar. And one of the things that he had learned, and we and I want to take this moment, I want to stop right there and take this moment. There's a belief by everybody, or maybe not everybody, but a lot of people, that the Supreme Court of the United States concocted the Downs versus Bidwell decision and pulled it out of their rear ends. They did not. It is a production of the outcome of the arguments at bar. They're telling you that was the federal government's official position at bar. That's what they're telling you. This The Supreme Court didn't create any of it.
Would it be a deviation if I
Okay.
said that I remembered? It seems like when I remember reading Barron's versus Baltimore, or we were discussing this, there was a question that you were talking about that directly relates to what the arguments were. And I think if I remember right, and I could be wrong, and maybe it's not relevant here, but where the Supreme Court was basically arguing whether the states actually wanted to entrust the federal government with power that wasn't rightfully theirs. Am I right in that? Is there any relevance? If there's
No,
not, let's move on. Okay. Never mind.
no, it can be seen that way through cynical eyes,
Okay.
but I don't take a cynical approach to the Supreme Court. I just
Okay.
don't. I
Okay.
hold them in the highest esteem.
Hmm.
Um, when John Marshall was listening and the rest of the court were listening to the arguments in Barron, something struck them, and they said, "Okay, here's what we're going to do." And you can read it in the case. We're going to go back through the adoption of the Bill of Rights, and we're going to try to ascertain what the intention was of the framers and of the states in pushing the Bill of Rights into the Constitution. We want to know, why did you do it? When they did that, they came to the same conclusion I came to. Same conclusion I came to. And that was this: the framers of the Constitution did not put the Bill of Rights in the Constitution. It was a demand of the people of the states as a requisite for ratification.
Right.
It's a negotiation.
Right.
It was put into the Constitution to limit the federal government
Hmm.
as a limiting factor, or we can say it this way. This is John Marshall, word for word, out of Barron versus Mary Baltimore. The Bill of Rights act as a restriction on government action.
Hmm.
And it was not put there by the government. It was put there by the people of the states as a condition of ratification.
Right. Got it.
Because of that, the Bill of Rights can only be construed to be a restriction on the national government, not the state governments, because it came from the states as a restriction against the national government. So John Marshall goes, because of that, I can't sustain this action against the state under the Fifth Amendment, because the Bill of Rights is not applicable against the states. And he was right. It was never designed to be put into the federal constitution to be operative against the states. 100%. But this created a problem. Now this the every human being that loves to abuse others and dominate others came to the United States going, hey, I can operate in the states and almost with impunity because the Bill of Rights are not operative against the states. And it started an era of corporations rushing into the United States because there was no restrictions against them working with the state governments to enrich the state, enrich all the people that were involved in it. So after a few years of this kind of shit going on, the Supreme Court of the United States says, look, if we don't do something, the people of the states are going to get ran over. We're going to get fucking ran. I'm sorry, pardon. We're going to get ran over, and we have to intervene. We
Right.
have to intervene,
Hmm.
and rightly so. And so they decided to start doing something called selective incorporation, which they were taking parts of the Bill of Rights and making them using their force. Well, there is no force in the Supreme Court, but using their judicial power, making certain parts of the Bill of Rights applicable against the states and restricting the states now from abusing their citizens or engaging in activities that could abuse their citizens because the states were engaged in some things that were abusing their citizens.
Hmm.
So the Supreme Court of the United States says we have to put a stop to this. If we don't, we're going to be in a out of control runaway situation. So that is the current status right now of the only reason why you can tort or sue the state government for violation of due process. If we would have went back to Barron versus Mayor of Baltimore in 1863 or whenever, or 1830 something, and we're operating at that time frame, there would be no way to get relief again if the state tramples on your rights. There,
Well, it looks to me that the selective incorporation used to prevent the states from abusing its citizens now has inadvertently allowed the federal government to abuse the states. And
this
it's
the
and it's allowed this not allowed, and it's conveyed to me very clearly that this vassal state arrangement in the fact that the court can not only create a an opinion that is now law, as if that isn't bad enough, but now it gets to determine what how to define life, how to be able to, now I think they're talking about the abortion pill, and I guess we're way off topic maybe, but where the federal government or is using the court to be able to determine, hey, can you guys redefine what gender and sex is and sovereignty and all these other issues? And it's like I hear him use the 14th Amendment all the time. And well,
well, that's
it's the First
because
Amendment through the 14th Amendment. And I thought, wait a minute. I mean, the 14th Amendment is that's a history, guys, in itself. I would strongly recommend learning about. But when you use the 14th Amendment, that just further confuses everything to where the citizens don't feel like they have any power and authority to do anything because they don't know who they are. Anyway, I didn't mean to go off the deep end on that because I know that we were talking about the book, but I figured that some of those principles were hugely important because I'm coming from a position where I've had my complete paradigm shattered because of you. I'm a better man
well,
for it,
I
but I'm bringing to the table the basic understanding that I have learned over the last 14 years that I know a lot of patriots, if you will, conservatives have come to believe. And
yeah.
this is such great information to be able to help us see things that we don't see. And that's kind of where I was coming
Well,
from.
let me point something out about the Supreme Court. There have been different courts that have done different things, and I'll give you an example of one of the things that you alluded to, but you don't know where it came from. Okay, there was a dude named Taney, Roger Taney. In fact, let's do a screen share, and I'll bring up this dude so you can see who he is. Roger Taney was one of the chief justice. He was a chief justice of the Supreme Court. He was after John Marshall. Now, the thing about Taney is that he wrote one time in one of his works that, and it might have been an opinion. I read a lot of stuff, so I don't know. I think it was an opinion now that I'm thinking about it. He wrote an opinion. And in this opinion, he stated this, and I'm paraphrasing, that the way that he saw federalism in the way that it was operating in his current time frame when he issued the opinion and wrote those remarks, that the states could be used as laboratories
Hmm.
for the experiment of different forms of federalism. Now, marinate on that for a moment. Just marinate on it. Just, you
I
got
don't
the
have to.
Supreme Court chief.
I don't think I
Right?
have to.
Yeah. So, I mean, and you had courts that were composed of people that thought some really far out there stuff, man. You can but the court that we have now is about as level-headed, and I would say that the majority of this court, I think, embodies more of a Justice Scalia, Antonin Scalia,
Hmm.
than any of the courts, even the court that Scalia was on. If you're an Antonin Scalia fan, and I'm a huge Antonin Scalia fan, right? Was my favorite judge besides Harlan Marshall. Um, but so I think the point that I'm trying to get to in all of this stuff is pointing to there are factions, and there always have been factions at work in the system that work some kind of evil against the system. But you can only make that statement really if you know what the system was supposed to be. And so that was the issue that I had with writing the book, is until I understood what was supposed to be, I've got nothing to compare anything to, right? As far
Right.
as I know, the system that we have now, unless I really dug in and did the research, could have been the system that was intended all along. How would I know? Unless I had the documentation to compare back to get a clear picture in my mind of what was intended by the founders. Only then could I write the remainder of the book and go, this is where we erred. This is where we erred. This is where we erred. You see,
Hmm.
you have to have something to compare back to. Okay.
For sure. Okay. So did we
So
go off on
Taney
a
was one of
deviation, or
those.
I hope there's some relevance to this, because we're still talking about the 98th meridian before we move into, yeah, we still got a couple pages before chapter 6.
All right,
So
so we
I
can
don't,
we can skip
sorry
a
about
little
that.
bit. That's okay. That's okay. These things are all important for the overall exercise of what we're doing, because there's going to be people that are going to listen to me talk, and they're going to go, "What the heck is this wingnut saying?" It
Yeah.
doesn't match anything that I think I know. It's like,
Right.
well, I can produce some level of receipt for everything that I say. So just so that
So
we're clear on that.
so define for us what the 98th meridian is for people that want to know. I
Okay.
have.
Um, The 98th meridian is one of the division points. It's a northern southern division line on the globe. It's a meridian, and it divides the globe up into meridian points, right? So that we can find any spot on the planet. So you got a coordinate system, and one of those coordinate systems that we use is this 98th meridian, or well, all the meridians, but for our purpose, the 98th meridian is that division line between the east west. That's your division line. And as we were going through this and finding all this government produced documentation that talked about the 98th meridian, I was made privy to John Wesley Powell, and I went go into this a little bit in the report that I got from Powell. And here's the citation from his work, Dividing Line, the Past, Present, Future of the 100th Meridian, Harvey Liefert, 2018, going back and looking at Powell's work. And they call it the 100th meridian, which is a little bit skewed further to the west. But as far as the government's documentation, they count everything because of the land program from the 98th meridian, and that's your dividing line. But this is a beginning of when water became an issue because they created this paper. Powell created this paper because he had done a hydrological report in the western United States and found that basically the 98th meridian was a dividing line between a very wet areas in the United States and very arid areas in the United States. So lots of water over here and not very much water over here. And it became a huge deal. His report, his geologic report, became a huge deal in Congress, even back then. And we're still feeling the effects of this today. So I get into that because again, he uses the 98th meridian as his dividing line in his reports. And the rest of this is just getting into other aspects of the admission program. Then I get into treaties and their impact on statehood. And this is where I get into the Rasmussen decision. And this gets into the incorporation, unincorporation issue. And would it help people if we looked at Rasmussen? Do you think?
At this point, I don't think it could hurt. I think more information. Well, I'm an information junkie, so I think it's important. You
Okay.
brought it up. You brought it up enough. I think it's probably important for us to at least give an overview for sure.
All right. So let's go into my case law files
Because
here.
that's in the incorporation unincorporation thing again. So I think it's good to have a firm understanding of what that is. Considering I'm still going,
I
okay, I
think
think I
so as
got it.
well. So I'm going to show you where this comes up in the case law, and that's probably the best thing that I could do for everybody right now,
And
I
that's
think.
4849 for people that are following along.
Okay, this is Rasmussen versus United States, 1905. This was only 4 years after the Bidwell decision, so it's the same court, all the same justices. Um, okay, I think it. Okay, here it is. We're just going to read this whole session. This is the syllabus, and this is the holding. This is the opinion. This is the outcome of the opinion. The syllabus, the holding, right? The treaty with Russia concerning Alaska, instead of exhibiting, as did the treaty with Spain respecting the Philippine Islands, the determination to reserve the question of the status of the acquired territory for ulterior action by Congress manifested a contrary intention to admit the inhabitants of the ceded territory to the enjoyment of citizenship and expressed the purpose to incorporate the territory into the United States. Under the treaty with Russia, ceding Alaska and the subsequent legislation of Congress, Alaska has been incorporated into the United States, and the Constitution is applicable to that territory.
So the state did follow the flag.
And under,
Sorry,
well, I don't know what that means.
never mind.
I mean, I know what it means in the way that they were talking about it in Congress, but here, um, only in Alaska.
Mhm.
And I say that, people go, no, if they did it in Alaska, they did it everywhere else. It's like, I'm sorry. I hate to be the guy that tells you that you're wrong. They didn't. You will not find this language that's right here in Rasmussen in any of the other treaties. It's not there. It's just not there. Okay.
Mhm.
And clearly the court here is saying, well, the language of that treaty incorporated it because it was passed by Congress. So Congress incorporated Alaska.
Right.
This
So Congress,
creates a massive problem.
Okay, so explain the last sentence or the last from it says
Let's go
an
through
app.
it slowly.
Okay.
The treaty with Russia concerning Alaska, instead of exhibiting, as did the treaty with Spain respecting the Philippine Islands, the determination to reserve the question of the status of the acquired territory for alternative action of Congress. Okay, what does that mean? What is the court saying right there? And let me highlight that. What is that saying? Because that says it all. If you can understand what they're saying right here, you get it.
They're creating Alaska as an insular area. Wait,
No,
okay. I missed it.
here I'll
Okay.
just I'll just
Say it.
okay. So what they're saying here is that the Russian treaty did the opposite of what the treaty with Spain did on the Philippine Islands,
Oh,
because it uses this contrary verbiage instead of exhibiting, as did the treaty with Spain
right.
and the Philippine Islands, meaning the Downs versus Bidwell decision. So you
Okay.
need to know what's said in the Downs versus Bidwell decision, because that's what they're talking about, and they had just handled this 4 years prior,
Mm,
so it was still fresh in their minds, and so they knew what they had decided in Downs versus Bidwell, and so they said, well, in the case of the Philippines and Puerto Rico, they're under Congress's exclusive power and unincorporated.
hmm.
So the treaty with Russia, instead of creating the same situation that they did in Philippines and Puerto Rico, the determination to reserve the question of status of the acquired for ulterior action to Congress. What they mean by that is hold as a territory, unincorporated territory. That's what they mean.
Okay.
Instead of choosing to hold Alaska as an unincorporated territory, they manifested a contrary intention and admitted the inhabitants of the ceded territory, Alaska, to the enjoyment of citizenship, and expressed the purpose to incorporate the territory into the United States. So, contrary to what was done in the Philippines and in Puerto Rico, they admitted Alaska on a completely different footing,
Okay.
contrary to what they found was going on in the insular areas.
Okay. I knew there was something.
Yeah,
I
so
got a
that's the
claim to
connection to the
like.
insular
Okay.
areas,
Okay.
right?
Good.
Right, because the
Okay.
Philippine Islands, right?
Good.
So that's what this is saying. And of course, the rest of the body of the text is just the legal rationales being presented by the court and how they arrived at their decision. But this is the holding. Okay. Now, if we use this same logic, if we have the Bidwell decision and we have the Rasmussen decision and the Balzac decision and the Dorr versus United States decision, and we have all these decisions and we read them, what would we conclude? Was the court consistent? Yes, they were.
Yes, there were.
What does it mean? It means that unless there is some official legislation by Congress organically or in a treaty when they acquired the property, those would be your, or in the admission acts, those are
And
the
they
three
would
shots
remain
Congress had.
for
I'm sorry, what?
incorporation. For incorporation, right?
Yep,
Okay.
yep. Those are
Good.
the three shots Congress had to incorporate the federal areas within the state boundaries domestically.
I'm sorry if I jump in. I'm just trying to,
And
in
you
an
won't,
effort to try to become more well versed, I've got to try to jump in and have you say yes or no.
sure,
It beats you
no
writing a
problem, no problem.
questionnaire for me, right? So I appreciate it. Yeah.
And I appreciate you jumping in and getting my attention, because man, I can just kind of range. But so this is critical when you look at the admission acts, when you look at the treaties domestically. I'm talking the domestic contiguous United States admission acts, treaties, and all the organic legislation. There is no incorporation language in any of them. And those are the three areas that I can isolate that Congress would have been able to legislate to incorporate those areas.
Right.
So when we found and the Department of the Interior, when we found their land classification internal documents, and all of the contiguous domestic territory was considered under exclusive power, that's why,
Mhm.
because they've not been incorporated.
Got it.
So it all proves out to be true when you look at the hardcore documentation. Okay.
Awesome. So you went
So
into,
go back to the book.
that takes us into 49, and then you go into unincorporation with Alaska, and you had,
And I'm getting into heavy explanations of what all this means
well,
and
that's
all
good.
that, and it's and there's all the other case law in there. You really just need to get the book because we don't need to go through it all. We're just rehashing stuff. Um, and I get into a little bit about the Eisenhower administration doing the audit or the land inventory. Talk about that, and then we're into chapter 6, and then now we're dealing with water.
All right. So we have, we started at 10 minutes before the hour. It's 40 minutes after the hour, so we have about 10 minutes. Do you want to end this thing right here and start fresh on chapter 6 and just leave
Yeah, I
some
want to
closing
start fresh
comments?
on chapter
Okay.
6. We can start. Yeah, but
Okay.
I thought, well, we covered some. We were talking before we started this video, and one of the things that I wanted to make sure I apologize to everybody for losing losing my cool in the last video, and I want to explain to everybody why that is. It's not just coming out of nowhere. There's a reason for it, but I can do better. So as far as what we were talking about, though, in the surrounding information, one of the things that struck me was the level of the level of getting people involved, right? So I don't know. There's so many aspects to the land program that I can involve everybody in the United States if I took long enough to explain how it affects everything,
I think
right?
the
Because if you're a hunter,
I think maybe, you know what? I
go ahead.
think it would probably be important for us if we had some help from the listeners, right? To be able to put the
Sure.
topics to help us put the topics down. So one of the things I focus on right now is the United Nations and Agenda 2030. Um, that is such a complex system because it is so invasive. It involves, it's like the land program. No matter where you go, you're going to run into the land program. If you understood what
Yeah.
was going on with any particular issue you're dealing with today, you can go back to the land program. In the
Yeah.
situation that I'm dealing with, I mean, I can talk about cops, I can talk about water, I can talk about watershed, I can talk about the environment, but I can break that down into subcategories. We can talk about food, private property, we can talk about healthcare, we can talk about all of these different things. So it might be great to give an overview, which I think is great for us to try to get people to understand the book. But I think at some point, which is why I think we do the other video series, is to talk about why this affects you. And I think that might be a back door for people to say, okay, I found this video that says, where they're going to be talking about, I don't know, some issue. Let's just say Baltimore, right? Since they had the attack the other day, right? It may or may not have something
Yeah.
to do with the land issue. But if we take the hot issues and we connect them in some way that they can be legitimately connected to the land issue, I think that's going to increase the amount of interest that we have in watching the videos and, of course, buying the book. So
Sure.
that's my
So
motivation. Help get people up to
yeah, and
speed.
I would love to hear from people. Nobody's been commenting. We've been getting lots of views, but not a lot of comments. And it would be a lot more helpful if people would comment, at least let us know where they're at. Not as a pejorative,
Mhm.
but just because it's a guidepost, right?
Right.
So if I know the level at which my listener is at cognitively on this issue, I can tailor the information at that level to some degree. I mean, I'm not an expert at this. I'm not a clinical psychologist or anything. Um, so I'm going to struggle a bit with that because there's skills that I don't possess there, but I could at least try, right?
Right.
And so without understanding where everybody's at, I don't even know where or how to try to tailor the information for them, right?
Well, and now that you're up against your business coming up shortly, that's going to make things even more complicated. So, and I
Yeah.
think there's things that can be done. My mind works actually overtime in thinking about ways to be able to get this word out. So I'm just hoping that people will engage. We can tell those that will actually listen this far because we should get some comments. They're like, oh, well, nobody got that far. Anyway, uh, we could
Yeah.
probably talk for hours, but so let's
Yeah.
conclude. If you have any final comments, we'll go ahead and we'll kind of do that, and then we'll end the video and we'll start with chapter 6 next time.
Yeah, I don't really have anything else to add. I think
Okay.
uh I my problem is I'll just end up making comments that'll just be confusing. So
Okay. All right.
just end it when you need to, you know.
All right. Well,
So
Ron, I thank you again for your time on the video. I know that you're a busy guy, and it's important for us to do this, and I'm glad to join with you and learn. If I can be your star pupil, somebody's going to have to do what they can to catch up with me, though, because I really love this topic. So I appreciate it again. Anybody that's interested, the website is the History of Federal Lands in the United States .com. Ron's the author for the History of Federal Lands in the United States and the Violence of Faction. Buy a book, support the author, become part of the solution. If you have any comments, questions, or anything, go to the website, or you can make a comment wherever you find this video. So I appreciate everybody's time. Thanks, Ron. Appreciate it.
thanks Tom for having me and thanks everybody for watching these.